A very good afternoon and welcome in the ring to this very special report. And we are reporting on the Parliamentary Secretaries case, the judgment of which has just been delivered by the Chief Justice Roxanne George Wiltshire. We'll be joined by one of the attorneys in that case, Mr. Roysdale Ford, and also the gentleman who brought that case, Mr. Christopher Jones, and we'll also be joined by Member of Parliament Ganesh Mahipal, who understands how the PPP and its duplicity works. So we want to ask you, as per normal, to share the live stream, and let's get going. We know that this is usually out of our usual broadcasting hour, but we had to come to bring you this very special report again of the Parliamentary Secretaries case coming out of the High Court, the judgment of which was just handed down by the Chief Justice. And I want to welcome this afternoon Mr. Roysdale Ford, Attorney at Law Roysdale Ford, Senior Counsel. Mr. Ford, a very good afternoon, sir.
Hi, good afternoon, Sherwood. How are you doing?
I am great. Congratulations.
Thank you very much. Thank you very much.
And of course, this is the Christopher Jones versus the Attorney General, the Speaker, Sarah Brown, and Vikash Ramkissoon case. Tell us a little bit about the background of the case, and then we'll talk about where we are currently.
Okay, Sherwood. This case became necessary to file this case because the PPP, after they would have extracted their 33 members for the seats that they would have been allocated after the 2nd March 2020 elections, they proceeded to appoint 2 parliamentary secretaries, the 3rd and 4th name respondents. And then by virtue of that appointment, they became members of the National Assembly. We believe from the fact that that would have happened, that they were not lawful members of the National Assembly. So we instituted the case against them, challenging their appointment and their membership of the National Assembly.
Great. Very, very great. Allow me to introduce also, as I said, joining us this afternoon is Member of Parliament, Mr. Ganesh Mahipal. Ganesh, welcome.
Thank you. Well, thank you, Shara. Thank you, Mr. Ford. I trust you are celebrating. I'm not celebrating the outing of those 2 parliamentary secretaries. Well, I should now say former parliamentary secretaries. But the fact that you had sound argument and it was based in law, and as a lawyer, you must feel accomplished knowing that you have fought a case that deservingly so won.
Yes, I feel that the case had merit. The Chief Justice indicated throughout her judgment that the arguments of the Attorney General and Mr. Manoj Narayan and Mr. Satram, who appeared for the Speaker, that they were without merit. She did it repeatedly in relation to every single argument that would have been advanced and raised by the Attorney General. So we have a conclusive determination of this matter, which would see the 3rd and 4th name respondents, the 2 parliamentary secretaries, being booted out from membership of the National Assembly.
Senior Counsel Ford, the line of argument that the Lord Attorney General took was quite strange. He was of the view that the Chief Justice and the High Court should not follow this case that concerns a similar verdict, and that was the Attorney General versus Desmond Morion, which is of the similar nature. It was a very, very strange line of argument, since the Court of Appeal was basically affirming the High Court's ruling.
Yes, the argument advanced by the Attorney General in that regard is absolutely without merit. You saw the Chief Justice made very short shrift of it, and she dispensed with that with ease. So the Attorney General had no hope, no possibility of ever succeeding in that sort of argument. The Court of Appeal is a superior court. When a Court of Appeal affirms the decision of a lower court, that decision formally becomes part of the Court of Appeal's decision. It becomes part of the stare decisis of the precedent. And moving on to the second consequence of that, it becomes a binding decision on all the lower courts. So what the Attorney General tried to do when he faced with the consequences of the decision of the Court of Appeal the affirmation of the decision of Justice Chang by the Court of Appeal, there was no option but really to concede. But rather than conceding, he sought to abandon his arguments and come back with a new argument that the decision of the Court of Appeal and, by extension, Justice Chang was wrongly decided, and that therefore what ought to happen in these circumstances is that the High Court should now arrogate onto itself the jurisdiction to set aside or basically refuse to follow the decision of the Court of Appeal. It's very bizarre. The Attorney General ought to know better and should not have presented that sort of argument that has absolutely no substance or merit to it.
Well stated. And in your arguments, you went to the heart of constitutionality. I mean, this is an administration that likes to talk about the Constitution and guardians of democracy and guardians of the Constitution. But here they were defending a case that went to the heart of constitutionality and what the Constitution dictates.
Yeah, Sherrod. Since the 2nd of March, we would have seen numerous instances where things like that would have been happening. Starting off from the appointment of Miss Orange Waldron, you remember that, Sherrod?
Correct.
So, starting with Miss Orange Waldron, then we had the issue of the two parliamentary secretaries. We had the issue now of the constitutional agencies, a very flagrant disregard and arrogation again onto itself, the executive, of power. They seem to be centered on accumulating power and subjugating independent organizations from functioning in the manner conceived by the Constitution. So we have that other case pending before the court that was filed in the name of our colleague Ganesh, the Public Service Commission, and other constitutional agencies join in that matter to demonstrate the importance of those issues. So, Sherrod, what you have happening here is a continuing march by the PPP to break down the democracy in this country, to abandon the constitutional system of governance. And you know, the Chief Justice quite rightly adopted something that I said in my submissions, which shows the ridiculous nature of what they sought to argue. The decision of the Court of Appeal, as affirmed by the Chief Justice, indicates clearly that you cannot be extracted, or not extracted, I should say, and simply be appointed and become a member of the National Assembly. If you take their arguments to the logical conclusion, as I did in my submissions to the court, on their national top-up list, Sherrod and Ganesh, I think I mentioned it to Ganesh, they had about 116 names. They won 12 of the 25 geographic seats, which means that they would have won 21 seats from the national top-up list. Those 21 names would have been extracted. It means if you take your argument to its logical conclusion, you can extract at least 95 more names. You could imagine a parliament functioning like that. So you tend to see the mindset of the PPP through the arguments that they come and present to the court. And it's very important that the ordinary members of society pay attention to these issues. They must understand that APNU AFC is fighting for them. They're fighting to support the constitutional order. And while all this is happening, you must recognize that the guardians of democracy, they were conspicuously silent. The Bar Association, which by its nature and functioning ought to be speaking out on these matters, they've gone very silent. The Private Sector Commission. So these entities have deprived themselves of their credibility. It can be suitable only for in your best interest sort of scenario. But these are important issues which are not being raised. We're hearing complete and deafening silence from civil society.
And MP Mahipal, again, this is why we see this duplicitous nature of the PPP. They preach one thing in one place, like the National Assembly, but then in other places, it's something totally different. These two MPs, I do not think it's a case whereby the PPP don't know better, but it's a deliberate attempt to hoodwink Guyanese to put those two parliamentary secretaries in the National Assembly, sitting there day after day, knowing fully well, like Onij Waldron, they are illegal. It's an attempt to hoodwink this country, not so?
Sherrod and Roysdale, I believe it was desperation at its best. The People's Progressive Party, through Anil Nandalal, tried a thing and they hoped to have gotten through with it. Because this very Anil Nandalal made an argument against such when in 2015, a matter of similar nature came up, which you referenced, Sherrod, the
Yes.
Desmond Morian matter, and Anil Nandalal argued against the appointment of two people who fell in a similar category. So to know that they championed constitutionality back in 2015, but now in 2021 they want to trample on that very constitutionality that they so wanted people to believe they represented well in 2015. I think it's not only duplicitous and hypocritical, but it's a matter of desperation. Because I can remember Anil Nandalal saying that the two parliamentary secretaries are going nowhere. So I want to put to Roysdale now and ask him from a legal perspective. I don't know if he will have to go and do some further research on this, but is it possible, in light of how the People's Progressive Party um, caused Onish Walron to be sworn in again after she would have received that certificate of renunciation. You know, when they got it, they swore her in a second time as MP. Could it happen in such a way now that the People's Progressive Party will write to GCOM requesting the removal of these two persons' names from the list of candidates, thus causing them not to be on the list anymore and facilitate them to be sworn in back as parliamentary secretaries? Is that possible?
That wouldn't be possible, Sherrod and Ganesh, but Nandalal has obviously deliberately either misled himself,
I think
or
it's that.
he would have misled the entire installed fraudulent government. This is Nandalal's doing. He said they were going nowhere, and he articulated a position that did not make any sense at all. The difference between the Onij Waldron situation, Ganesh and Sherrod, and the current situation is that in relation to the two parliamentary secretaries, or the two ex-parliamentary secretaries now, they never were capable of satisfying the constitutional qualification to be appointed. You have to be off the list. They would have been on the list, they would have been elected. Election day came, and persons would have voted and casted votes in favor of that list. So that is something that it is beyond rationality, and even beyond the PPP. Maybe not beyond them to attempt it, but it's certainly beyond any common sense, and the law would not permit it.
Okay.
Roysdale, for just for those persons who are now joining us, we are looking at the parliamentary secretary's case, is a short name, the verdict of which, the judgment of which has just been handed down by the Chief Justice Roxanne George Wiltshire. The longer name of the case is Chris Jones versus the Attorney General, the Speaker, and parliamentary secretaries Sarah Brown and Vikash Ramkasoon. And again, the Chief Justice has ruled saying that it is illegal for them to sit in the National Assembly because their names was extracted off of the PPP's list. It should not be. That is the basic aspect of it. I almost said Attorney General Ford. Same thing. Senior Counsel Ford. Senior Counsel Ford, in your submission, again, you went to this legal doctrine of the court enhancing certainty and predictability, based on the fact, again, that Nandalal was pursuing this line of argument, which says that the High Court, doesn't have to follow the High Court's own judgment or the Court of Appeal in the Desmond Morian versus the Attorney General case of similar nature. I mean, I'm trying to put context to understanding the beast that is the PPP, that would go to court and offer this line of argument. And you know
In a
one,
barefaced manner, Sherrod, in a barefaced manner, it is desperation, but you ask the senior counsel.
No. Ganesh is absolutely correct. It is an act, not only an act of desperation, but I see it as something a bit more sinister. I see it as the fact that they are determined at all costs to have their way. They're determined at all costs to ensure that the rules must bend, break, or submit to the will of the PPP. You know, we have to go back, Sherrod, to the Onish Waldron situation. Miss Waldron apparently informed the PPP officials that she did not satisfy the qualifications. They knew that she did not satisfy the qualifications. I had to write the letter. We had to get out in public to obtain from the Speaker and the Clerk of the National Assembly a document which will show that she did not qualify. We had to go and file a court matter.
yes,
You remember all of this?
yes, and
Went
and 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 even Onage herself publicly went through all kinds of contortions through Facebook posts, trying to show that she had given up her citizenship prior to September 1, before she took that oath. And you know what is even more hurtful? I will say this again, Royce, to show the sinister and bestial nature of the PPP. Onish Waldron went to the National Assembly just like Ram Kisoon and Miss Brown, and put her hand on that Bible, that Gita, and swore, that they were telling the truth, and that they whatever the oath is, took that oath on the Bible or whatever before this country and misled this nation. And that is what the PPP is encouraging. How can we believe anything that comes out of the PPP?
but this is so much in keeping with character. It is exactly in keeping with how they would have gone about events. You know, Sherrod, the interesting thing is that as part of the submissions, um, Nandalal sought to justify the presence of the two parliamentary secretaries, saying that the PPP would have done this before. He told the court that Joseph Hamilton was a parliamentary secretary. Um, and when the court inquired from him whether he was on the list, he said no. But I think he referred to Pauline Sukai. So the PPP has a long track record of bending the
Of,
constitution to suit them.
of breaking it, Roysdale, that's not bending, that's breaking it.
Yes, of course. Bending, breaking, seeking to um, have their will prevail against the express provisions of the constitution.
And in that context, both Roysdale and Ganesh, we have had this whole report coming out of the State Department of Human Rights, in which they call the PPP administration an installed one. Put into context for this country, Guyanese at home and in the diaspora, the kind of administration that we're dealing with on the ground, because some people get the impression that this is a different beast, but it's the same old PPP.
It's the same old, but you're correct, Sharon. It's the same old PPP. But I want to turn our attention to elections petition 88, and I think that in a similar way, and I have no I read a lot, but I'm not a legal person in the sense of well, some people call Roysdale senior counsel and they call me junior counsel. So I may have some idea. But Roysdale, I believe that the elections petition 88 is going to be victorious also, primarily because the arguments made is sound in law. If the Chief Justice is to make a ruling that is against our position, it means that every election going forward, we will have to have a national recount. And I don't foresee that being logical because the Representation of the People Act is clear and it spells out the methodology on how you arrive at a final result that leads to a final declaration. And no part of that speaks to a new regime, if I may use that word, in the sense of having a national recount order. So I think that this is the stepping stone. One would agree that this is the stepping stone to also a successful ruling on elections petition 88. And it goes again to show that the PPP knows the correct argument. They know the correctness of the law. But for some reason, and I can only put it as desperation, they are deliberately trying to mislead the people of this country with their callous behavior and uncouth methodology of presenting cases that are baseless, null, and void.
Right there.
Well, I believe that the petition number 88, that we will prevail, that we will be successful. But Ganesh and Sherrod, there's another important element which I wish to add.
Go right ahead, sir.
It demonstrates the importance of petition 88 and importance of a petition and possibly a decision that will come down in our favor, which we hope and have every expectation that that will be so. You see, one of the issues, Sherrod, is that you have to bear in mind what really happened and what are the consequences of um, having a recount. Not only would have a sort of regime parallel or inconsistent with the constitutional representation of the people actually come into effect, but what it opens up, Sherrod and Ganesh, is a greater, and as I said before, I'll use the same word again to apply to this circumstance, is a certain sinister nature. Imagine, as I said on another show a few weeks ago, 7 members of a commission, together with a chairman, a majority of which will be 4, deciding that they don't like the results of the election. So they, among themselves, they decide simply to have a recount, and they go through the recount. We all were part of the recount, and you realize that individual decisions were made in relation to individual objections which were inconsistent. At recount station number 1, what was being said as a valid vote was different from what is being said on recount station number 50. Imagine a sort of arrangement, a sort of conspiracy being put in place and a plan being executed, whereby they could go through the entire ballot cast and determine an outcome and arrive at an outcome that is suitable to them, which actually goes against the will of the people. So Sharon and Duncan, Sharon and Ghani, sorry, this is a very important case. Is a case which is geared at pulling back and securing democracy, because you really can't have 7 persons, despite how meritorious or laudable they may be, or how well-meaning, well-intentioned they may be. You can't have 7 persons deciding by a majority of 4, or maybe all 7 of them, or whatever proportions it may arrive at, simply to determine the outcome of an election. The election is determined by the people. If you have a problem with the results of the elections according to the process as laid down, you file an election petition. That is a universal process.
Great. Senior Counsel and MP, over the weekend, I heard you say, Roysdale, on the same issue of the elections petition as you're there. But just for the purposes of those persons who are now joining us, we're talking this afternoon in this very special In the Ring report of the Parliamentary Secretary's case, where the Chief Justice, Justice Roxanne George Wiltshire, has just ruled in favor of Senior Counsel Roysdale Ford and others that 2 parliamentary secretaries, 2 members of parliament, appointed by the PPP installed regime, are sitting or were sitting in parliament illegally, just like Ms. Onish Waldron was sitting illegally. The Chief Justice has said they too were sitting illegally. One wonders, Senior Counsel and MP Mahi Paul, who else for the government, for this installed administration, sitting illegally in the National Assembly?
Well,
we may very well have to look at Ashley Singh now.
And also, Senior Counsel, there is some contention with the parliamentary minister signing documents on behalf of cabinet based on the fact that the Secretary of Cabinet cannot be a minister. So there is that also
As you mentioned, Sherrod, it is a long list
of
of
legalities. Yeah.
constitutional breaches and continuous illegalities. As I, in an interview yesterday, I think it was with Mr. Wendell Badri, I was asked almost the identical question. Um, how many other persons are sitting in government suffering from similar um, incapacities? And I indicated to him, as far as I am aware, that there were a considerable number of other persons in similar situations, might not be identical, but that we will be reviewing, and we had engaged or started the process of reviewing the circumstances as far as we are aware of them in relation to all of them. So we will continue to file proceedings touching incapacity, legal or constitutional incapacity of persons to sit in office, and all other breaches which we are in a position to bring before the court readily.
Great. Thank you
Sherrod,
very
if I may, Sherrod, if I may ask
much.
Roysdale, I wanted to know what directly are the orders that were granted by the court.
Great. I was coming to you.
My apologies.
Great ahead, Roysdale.
Well, the Chief Justice ordered, in effect, she granted two declarations in relation to each one of the parliamentary secretaries. She granted declarations that they are not qualified to be members of the National
Which
Assembly.
means they're out.
She
Sarah
also
Brown and Rapid soon.
Yes, and she
And
also
Natasha
said
Ampersoon.
in her decision that they were not qualified to be appointed to be members of the National Assembly. I had conceded orders speaking about the issue of their appointment as parliamentary secretaries, and I had during the submissions and in my written submissions to the court, to ask the court to zero in on their membership of the National Assembly, because that issue and a determination in our favor will render also unnecessarily nugatory as a matter of consequence their appointment, which could be dealt with in other ways. So as we speak, the court ruled that they were incapable of sitting in the National Assembly. So the very moment the Chief Justice pronounced those words, they failed to be members of the National Assembly.
Great Senior Counsel. Ganesh, Senior Counsel was talking early on about, these guardians of democracies whose voices, guardians of democracy, whose voices were so loud in the past. And again, just recently and over the weekend, I heard Senior Counsel talk about how democracy is not a one-day process. Where are all of these folks, especially the Bar Association, which should be like a watchdog on these very issues?
Sherrod, the guardians of democracy, that false name that they pinned themselves to, were for the specific purpose of trampling on democracy. Their actions stymied democracy. Their actions really created a narrative to paint this picture as though the People's Progressive Party was standing solid on democracy. And as days go by, we are unearthed. A lot of things are unearthed by the actions of the PPP and is being revealed in the court of our country. And I say to you that those guardians of democracy, they have received their 30 pieces of silver and they're in their corner spending their 30 pieces of silver. The real guardians of democracy are people like Roysdale Ford, who is standing up in court fighting for what is democratically correct and in keeping with our constitution. The real guardians of democracy are people like yourself who come on air every single night to educate and edify our people on what is happening in our country. The real guardians of democracy are the people who read the Constitution of the Cooperative Republic of Guyana, adhere to what is said in the Constitution of the Cooperative Republic of Guyana, and put it into practice. The real guardians of democracy are people who have that respect for the Constitution, love and adoration for what is in the principal belief of our country, and not the persons who are trying to just gain popularity and fame for a couple of morning and then desperately showing up inside the courthouse, advancing arguments that are of a nullity. That is really and truly what guardians of democracy is supposed to be. And I believe that the real guardians of democracy are showing their faces now, and they're showing it with full confidence and credibility, especially in their arguments to defend what is written in the Constitution of Guyana.
Great. Senior Counsel, coming up, we have on the 14th, the appeal for elections petition 99 is going to be heard. On the 14th of June, that is, rather, the appeal for election 99 is going to be heard. And on April 26th, we have the Chief Justice ruling on petition number 88 that is going to be coming up. Expectations?
Well, I expect to be successful. I expect the APNU AFC coalition. I expect the team to be successful because not only would we have presented or intend to present in relation to the Court of Appeal sound and meritorious arguments, but the victory would be a victory for all Guyana. It would be a victory to support the Constitution. It would be a victory in keeping with the expectations of the ordinary Guyanese people that we have a constitutional system that works, we have a judiciary that works, and the rule of law must ultimately be upheld by the courts. I expect also, in relation to the issue of the parliamentary control, which has been usurped by the executive, by the Fiscal Management and Accountability Act that was being passed. I know you haven't mentioned that, but that is something that I am very strong about. I believe that it is a crass arrogation of power to the executive. And we must understand that the APNU AFC introduced in 2015 in relation to this issue. And I'm very upset about it, and I feel strongly about it. So I know I go back to it over and over because I believe it is a very dangerous development, Sherrod. If you would allow me again to just
go right ahead, sir.
Speak to our listeners about this. In 2015, when APNU AFC came into power, one of the first acts, and it's almost ironic, I pay attention to certain circumstances. One of the first acts of the APNU AFC in 2015 was to introduce the Fiscal Management and Accountability Act of 2015, an act which restored or gave effect to constitutional independence of all the agencies mentioned in the Constitution, all the commissions, all of them. They were able to present to the National Assembly their budgetary financing that is requested. If the executive has a problem, they have to go before the National Assembly and present an alternative case. So the entire country would have known whether the government was against a particular agency, a particular constitutional agency or commission, whether they were trying to suppress or target such an agency. That is the sort of legislation that you have in a functioning democracy. And that is the sort of constitutional arrangement that our constitution perceived and considered that is necessary for the functioning. So we had the blossoming of those agencies functioning independently. No minister to tell them how much they must spend, why they must spend it, how much they must spend it on, or anything of that sort.
Yeah.
Now, what would have been among the first bills brought in 2021? The first major bill brought to this House that we are currently members of was the Fiscal Management and Accountability Act 2021, brought by the PPP for the sole purpose of undoing that independence which we give and which the Constitution requires for all these constitutional agencies to function effectively. So they passed the Fiscal Management and Accountability Act of 2021. What are the consequences, Sherrod, of this act? This act rendered all the constitutional agencies budget agencies, and effectively, by Section 14 of the Fiscal Management and Accountability Act, every constitutional agency now falls under the control of a minister of the government. And the constitutional agencies now have to present their budgets or budget proposals and submissions to all these ministers for approval. So these ministers now can now determine not only total quantities or total sums of money to be spent, but the particular projects that the agencies or commissions could spend those monies on. So you understand the radical departure from what the Constitution contemplates, from what APNO FC put in place in 2015. So it dovetails, Sherrod and Ganesh, if you permit me to say so, it dovetails into the continuing mindset. We see it over and over again in different ways. We can see it in dangerous ways where the PPP ultimately want to have control over every single thing in this country. And
Control freakism.
Nandalal is at front and center of this attack on the Constitution. You used to hear him saying that he's the guardian of the Constitution. The Attorney General, I am the guardian of the Constitution. The guardian of the Constitution is the court. So that is a false statement he would make repeatedly.
Yeah.
But nevertheless, as an Attorney General, you have an obligation to uphold the tenets of the Constitution. And a fundamental one is the independence of the constitutional agencies. And there you have an Attorney General bringing a bill that would undo that. And what you know what else he would have done, Sharon and Ganesh? The Appropriation Act would have been passed on the night of the 4th after that little terrorist would have attacked our sister colleague here when we came
Yes.
out.
Yes.
Do you know that that bill would have been passed that night? The constitutional agency's case was fixed for hearing on the 5th of that would be March, the 5th of March. Do you know that by the morning, the installed fraudulent president would have signed that bill into law and it would have been published and gazetted? All because they want to ensure that the court is placed in what the ordinary people in the streets would call a section, right? That the court will be compromised by their own independent acts to ensure that the court's efficiency and effectiveness of granting a remedy to deal with these situations would have been compromised. So, whilst they may have succeeded in a basic short term nature, and that is the PPP, all they're interested in is pushing ahead with short term successes because they will soon get long term failures. Because the court is ultimately going to have to decide this matter. That case is fixed for determination or arguments at least on the 13th of May. So these are the issues that are confronting people. So I understand it is our job to bring these issues out to the public. We're going through the period of COVID. People are unemployed. People are lacking in resources, opportunities. So I personally understand, whilst I would expect people to be paying attention to these issues, I understand the very struggle that people are going through at this stage. And I want them to understand that after here, we will be continuing to fetch the burden with you and for you.
Great. And actually you provided the closing that I was coming to, because and I'm still going to ask Ganesh and even come back to you, Royce. As we close this special report this afternoon, there's lots of fears out there as it concerns the PPP's administration, their installed administration. What do we say to Guyanese? Because sometimes there's the impression as though the opposition isn't working, but we are always working, and more so in circumstances like these where you have to confront the constitutional excesses and illegalities of this administration. What are your thoughts to Guyanese this afternoon?
Well, I would say to Guyanese, as I always do, and that is to stay the course. Stay the course. It is, sometimes people say long time done, short time left. But the end result of everything is that the coalition is strong, the coalition is ready to fight for the Guyanese people. The coalition has been fighting for the Guyanese people, and the coalition will continue to fight for Guyanese people. You know, I was telling of, I was on a program earlier, Girl Power, Melissa Davy, and I told her, I said the coalition is a democratic political movement where persons are joining it on its merit, not for the sake of just being a part of a political organization. And I implore on Guyanese to examine the two major political parties or political organs in this country. It is the People's Progressive Party and the coalition. The People's Progressive Party is a dictatorship. There's no doubt about that. And we see it from their attitude and their behavior. And Roysdale, not to say that Anil Nandalal doesn't know his work, but I believe Anil was instructed to go and fight these cases and take those kind of line, because I can't find in my head, nor can I fathom the belief that a person who has been in practice for so long would put up such frivolous arguments. I can't fathom that. I can't comprehend that. I remember Anil Nandalal lost the other day to Darren Wade in the Haitian case. So sometimes I wonder if, as senior as he is in the People's Progressive Party, that it could be that he is also subject to dictatorship. He is also instructed to go and do this, even if it has no merit. And instead of doing what he had to do, which was to file the paper so that Jagdeo would not have to have paid Annette Ferguson 20 million. I don't know if he paid it as yet. But the point is, they run away from arguments that are strong, and they put up baseless and frivolous arguments to cases that are basically not worth the arguments that they want to put forward. And that speaks to the dictatorship in the PPP, and how these people who are supposed to be lawyers are being dictated to get their work done, and embarrassing themselves in the end result, because the dictators are not the ones at the front who face the brunt of it. But then you come to the coalition now, which is a democratic organ. Roysdale, you know that anytime we need legal advice, we don't turn to Sherrod Duncan or Ganesh Maipal. We turn to our legal minds. If we need sociological advice, we will turn to Sherrod Duncan. Or if we need geological advice, they will turn to Ganesh Maipal. Or if they need family advice or guidance or those kind of things, we turn to the people that possess the requisite skills to give the advice. And that is how we operate. That's a democracy where you respect people and their views, and you cushion the whole situation to satisfy what was presented. That is the difference between the two, Sherrod, if I may put it that way. And I want to say to Guyanese people to stay the course. A long time done, short time left. And the coalition is going to return to office. There's no doubt about that. Democracy is on our side, the rule of law is on our side, and we have the majority of supporters out there that want to see us back in office, because they have this period of the PPP where they have seen public servants have nothing to get. And the ordinary Guyanese people are not considered in this COVID pandemic. The Speaker of the National Assembly has taken a decision to protect his MPs and the Parliament staff, but still our ordinary citizens are out there suffering and at the whims and fancies of the PPP. So stay the course, hold the strain, hold the line of battle. The coalition will return. The coalition is your coalition, and the coalition is for the grassroots. The coalition is for the ordinary Guyanese. And have no fear, we will be back to ensure that we take this country to higher heights with your cooperation, your sincerity, and together we will stand and move Guyana forward. Thank you.
Stay the course. Senior Counsel.
Well, Sherrod, I understand and I agree and endorse what Ganesh is saying, but I think that he is being a bit too charitable to the PPP. I don't believe that Nandalal is sent out to argue cases that he don't believe in. I believe that underpinning the PPP is a certain mindset. It's a certain approach to issues, a certain approach to governance. And the undemocratic nature, which is at their essence and at the core, which you see it manifested in the organization as a whole, you see them extending and implementing that in the public. So what you see, right, Ganesh and Sherrod, and the public would see, is simply them following through on their decisions. So it's a sort of a suicidal kamikaze type approach. We know this may not work. We don't care if it works, but our fundamental position is that PPP and whatever we decide in our little group, we that must what it must be. I have no sympathy for Nandalal. I believe that he subscribes to the party's position. He's a senior member of the PPP. We see how he would carry on in Parliament. We see the statements that he would make. There's no air between himself and the PPP. They will fight among themselves. They will come back and sink next to each other, and they will come back and sit from the same cup, the cup of executive lawlessness and arrogance.
Great. Senior
The cup
Counsel,
of poison.
the poison chalice. Senior Counsel Royce Ford, congratulations again on your judicial victory. MP, Member of Parliament Ganesh Mahipal, thank you for your presence and your
Junior
contribution.
counsel, Sarah. Junior counsel.
Junior Counsel. Fellas, thank you for stopping by in the ring in this special report. Thank you.
Thank you
Thanks,
for
sir.
Great.
Thanks.
Members of the public, this has been a special report of In the Ring. We've been looking at the Parliamentary Secretary's case. The long name for this case is the Christopher Jones versus the Attorney General, the Speaker, Sarah Brown, and Vikash Ramkissoon. And the Chief Justice, Roxanne George Wilshire, has said very definitively that just like Onij Waldron, that Sarah Brown and Vikash Ramkissoon have been squatting in the National Assembly and that their membership in the National Assembly is illegal and they must vacate their seat. That was the definitive judgment of the Chief Justice, again, the Honorable Roxanne George Wilshire, moments ago, in the High Court. And we want to thank you again, Guyanese at home, in the diaspora, and internationally for joining this very special report of In the Ring. Thank you, guys, and we'll see you guys back at 8 o'clock. Randy Critchlow in the afternoon rush will pick up on this broadcast and discussion at 5:30, and then I'll be back in the ring at 8:30 to continue our reporting on this and other issues. Thanks for joining again. Thanks for joining.